We at the Dhamma Sahita channel have been trying to spread awareness regarding Uniform Civil Code and personal law. Following are the views of Dr. Babasaheb Ambedkar regarding Uniform Civil Code presented in the form of question and answer. These views are provided verbatim in order to remove any doubts in the minds of audience regarding the original source. First question. During the Constituent Assembly debate on 23rd November 1948, Honorable Member of Constituent Assembly, Mr. Hussain Imam, asked the question to Honorable President of Drafting Committee, Dr. B.R. Ambedkar, that whether it was possible and desirable to have a uniform civil code of laws for a country too vast as this is. Honorable Dr. B.R. Ambedkar answered the question and he said, "My friend Mr. Hussain Imam, in rising to support the amendments, asked whether it was possible and desirable to have a uniform code of laws for a country so vast as this is." Now I must confess that I was very much surprised at that statement, for the simple reason that we have in this country a uniform code of laws covering almost every aspect of human relationship. We have a uniform and complete criminal code operating throughout the country, which is contained in the penal code and the criminal procedure codes. We have the laws of transfer of property, which deals with property relations and which is operative throughout the country. Then there are the negotiable instrument acts, and I can cite innumerable enactments which would prove that this country has practically a civil code uniform in its content and applicable to the whole of the country. The only province the civil law has not been able to invade so far is marriage and succession. It is this little corner which we have not been able to invade so far, and it is the intention of those who desire to have Article 35 as a part of the Constitution to bring about that change. Therefore, the argument whether we should attempt such a thing seems to me somewhat misplaced, for the simple reason that we have, as a matter of the fact, covered the whole lot of the field which is covered by Uniform Civil Code in this country. It is therefore too late now to ask the question whether we could do it. As I say, we have already done it. The second question, whether the Muslim personal law so far as this country was concerned was immutable and uniform throughout the whole of India. Honorable Dr. B.R. Ambedkar answered the question and he said, coming to the amendments, there are only two observations which I would like to make. My first observation would be to state that members who put forth these amendments say that the Muslim personal law so far as this country was concerned was immutable and uniform throughout the whole of India. Now I wish to challenge that statement. I think most of my friends who have spoken on this amendment have quite forgotten that up to 1935 the Northwest Frontier Province was not subject to the Shariat law. It followed the Hindu law in the matter of succession and in other matters, so much so that it was in 1939 that the central legislature had to come into the field and to abrogate the application of the Hindu law to the Muslims of the Northwest Frontiers Province and to apply the Shariat law to them. That is not all. My honorable friends have forgotten that apart from the Northwest Frontier Province, up till 1937 in the rest of India, in various parts such as the United Province, the Central Provinces and Bombay, the Muslims to a large extent were governed by the Hindu law in the matter of succession. In order to bring them on the plane of uniformity with regard to the other Muslims who observed that Shariat law, the legislature had to intervene in 1937 and to pass an enactment applying the Shariat law to the rest of India. I am also informed by my friend Sri Karunakaran Menon that in North Malabar, the Marumakkathayam law applied to all, not only to Hindus but also to Muslims. It is to be remembered that the Marumakkathaim law is a matriarchal form of law and not patriarchal form of law. The Musalmans therefore in North Malabar were up to now following the Marumakkathaim law. It is therefore no use making a categorical statement that the Muslim law has been an innumerable law which they have been following from ancient times. That law as such was not applicable in certain parts and it has been made applicable 10 years ago. The third question, thinking of Dr. Ambedkar about saving of personal law, and Honorable Dr. B.R. Ambedkar answered this question and he said, coming to the question of saving personal law, I think the matter was very completely and very sufficiently discussed and debated at the time when we discussed one of the directive principles of the Constitution which enjoins the state to seek or to strive to bring about a uniform civil code, and I do not think it is necessary to make any further reference to it. But I should like to say that if such a saving clause was introduced into the Constitution, it would disable the legislature in India from enacting any social measure whatsoever. The religious conceptions in this country are so vast that they cover every aspect of life from birth to death. There is nothing which is not religion, and if personal law is to be saved, I am sure about it that in social matters we will come to a standstill. I do not think it is possible to accept a position of that sort. Fourth question, whether there is a necessity to limit the definition of religion. Honorable Dr. B.R. Ambedkar answered the question and he said, there is nothing extraordinary in saying that we ought to strive hereafter to limit the definition of religion in such a manner that we shall not extend beyond beliefs and such rituals as may be connected with ceremonials which are essentially religious. It is not necessary that the sort of laws, for instance, laws relating to tenancy or laws relating to succession, should be governed by religion. In Europe, there is a Christianity, but Christianity does not mean that the Christians all over the world or in any part of the Europe where they live shall have a uniform system of law of inheritance. No such thing exists. I personally do not understand why religion should be given this vast, expansive jurisdiction so as to cover the whole of life and to prevent the legislature from encroaching upon that field. After all, what are we having this liberty for? We are having this liberty in order to reform our social systems. Fifth question, it is mandatory to state to exclude the personal law from judicial system due to our social system is conflicting with fundamental rights? And Honorable Dr. B.R. Ambedkar answered this question and he said, our social system, which is so full of inequities, so full of inequalities, discriminations and other things which conflict with our fundamental rights, it is therefore quite impossible for anybody to conceive that the personal law shall be excluded from the jurisdiction of the state. Having said that, I should also like to point out that all that the state is claiming in his matter is a power to legislature. There is no obligation upon the state to do away with personal laws. It is only giving a power. Therefore, no one need be apprehensive of the fact that if the state has the power, the state will immediately proceed to execute or enforce that power in a matter that may be found to be objectionable by the Muslims or by the Christians or by any other community in India. Sixth question, can government exercise its powers in such a manner as to reconcile the sentiment of different communities and not to provoke the Muslim community to rise in rebellion? Honorable Dr. B.R. Ambedkar answered the question and he said, we must all remember, including members of the Muslim community who have spoken on this subject, though one can appreciate their feelings very well, that sovereignty in the exercise of that power must reconcile itself to the sentiments of different communities. No government can exercise its power in such a manner as to provoke the Muslim community to rise in rebellion. I think it will be a mad government if it did so, but that is a matter which relates to the exercise of the power and not to the power itself. Seventh question, whether the state will exercise the sovereign power without reconciling the statement of different communities and not to provoke Muslim communities. Honorable Dr. B.R. Ambedkar answered the question and he said, I should also like to point out that all that the state is claiming in this matter is a power to legislate. There is no obligation upon the state to do away with personal laws. It is only giving a power. Therefore, no one need be apprehensive of the fact that if the state has the power, the state will immediately proceed to execute or enforce that power in a manner that may be found to be objectionable by the Muslim or by the Christian or by any other community in India. Sovereignty is always limited, no matter even if you assert that it is unlimited, because a sovereignty in the exercise of that power must reconcile itself to the sentiments of different communities. No government can exercise its powers in such a manner as to provoke the Muslim community to rise in rebellion. I think it would be a mad government if it did so. Eighth question, whether the application of the code is mandatory or voluntary. Honorable Dr. B.R. Ambedkar answered the question and he said, my second observation is to give them an assurance. I quite realize their feelings in the matter, but I think they have read rather too much into Article 35, which merely proposes that the state shall endeavor to secure a civil code for the citizens of this country. It does not say that after the code framed, the state shall enforce it upon all citizens merely because they are citizens. It is perfectly possible that the future parliament may make a provision by way of making a beginning that the code shall apply only to those who make declaration that they are prepared to be bound by it, so that in the initial stage the application of the code may be purely voluntary. Parliament may fill the ground by some such methods. Ninth question, is there any basis to decide the code is mandatory or voluntary? Honorable Dr. B.R. Ambedkar answered the question and he said, this is not a novel method. It was adopted in the Shariat Act of 1937 when it was applied to territories other than the Northwest Frontier provinces. The law said that there is a Shariat law which should be applied to Muslims, provided a Muslim who wanted that he should be bound by the Shariat Act should go to an officer of the state, make a declaration that he is willing to be bound by it, and after he has made that declaration, the law will bind by him and his successors. It would be perfectly possible for Parliament to introduce a provision of that sort, so that the fear which my friends have expressed here will be altogether nullified. Reactions of Law Commission of India, Supreme Court of India and Government of India Law and Judiciary Department on Dr. Ambedkar's explanations in Constituent Assembly. Law Commission of India's reaction on Dr. Ambedkar's explanation in Constituent Assembly as follows. Ambedkar's position in the Constituent Assembly debate towards a uniform civil code was that such a code would be desirable but for the moment would remain voluntary. Government of India Ministry of Law and Justice Legal Department, New Delhi, given reference as follows. The founding fathers of our constitution, being conscious of the difficulties involved in achieving the objective, have thus placed it in the part relating to the directive principle of the state policy in the constitution. A. The difficulty in framing uniform civil code was stressed by Dr. B.R. Ambedkar when Article 44 of the Constitution was being adopted by the Constituent Assembly. Dr. Ambedkar had then observed thus, I should also like to point out that all that the state is claiming in this matter is a power to legislate. There is no obligation upon the state to do away with personal laws. It is only giving a power. Therefore, no one need be apprehensive of the fact that if the state has the power, the state will immediately proceed to execute or enforce that power in a manner that may be found to be objectionable by the Muslims or by the Christians or by any other community in India. Sovereignty is always limited, no matter even if you assert that it is unlimited, because a sovereignty in the exercise of that power must reconcile itself to the sentiments of different communities. No government can exercise its power in such a manner as to provoke the Muslim community to rise in rebellion. I think it would be a mad government if it did so. Government of India, Ministry of Law and Justice, Legal Departments, New Delhi. B. While summing up his arguments on rejecting the amendment suggested to draft the Article 35, now Article is a 44 of the Constitution by Mr. Muhammad Ismail Sahib, Dr. Ambedkar had given a categorical assurance to the Constituent Assembly in the following words. And Dr. Ambedkar said, "My second observation is to give them an assurance. I quite realize their feeling in the matter, but I think they have read rather too much into Article 35, which merely proposed that the state shall endeavor to secure a civil code for the citizens of the country. It does not say that after the code is framed, the state shall enforce it upon all citizens merely because they are citizens. It is perfectly possible that the future parliament may make a provision by way of making a beginning that the code shall apply only to those who make a declaration that they are prepared to be bound by it, so that in the initial stage the application of the code may be purely voluntary." Thank you for giving your undivided attention to this video. We should let as many people as possible know about these subjects. If you think that we are providing you with valuable information and that this channel should go on, please do consider liking this video and subscribe to the channel. Do comment on the video and share it forward for the further engagements. If you want more information on this topic, you can refer to the books written by Advocate Dilip Kakade. Also, you can check out other videos on this channel. If you have been with us so far, thank you so much once again. Thank you.